Everyone gonna be ready to go at 9 o'clock?
Ready.
Yep.
I'm ready.
All right, good morning, everyone. I'm Commissioner Easterday, and this is my Thursday morning default calendar. So what I'm prepared to do is, if this is your first time being before me, I'm going to call each case one at a time. So I'm going to thank you for your patience in advance. So just going to call the case one at a time. Hi. So let's go ahead and call the first case on my calendar, which is in the matter of Sunset 314 LLC versus Michael Cattell et al. We got some cross claimants: Horizon Real Estate Group et al. Versus Cross Defendant Safeguard Capital Corporation. Jeff Peterson. Gosh, I think that might help. I think that's everyone. But nevertheless, the case number is CV 2024-004659. Can I go ahead and get appearances? Let's go ahead and get appearances first let's go ahead and get appearances.
Good morning, Your Honor. Richard Gramlich, appearing on behalf of Sunset 314 and Sunset 5 LLC.
Good morning, Your Honor. Vincent Miner on behalf of NAI Horizon and Christopher Lewis.
Good morning, Your Honor. Larry Fink. I'm the principal of Sunset 314 LLC.
Anyone else here on this matter? I think I tried to rattle off all the parties. This is a big case, guys. So anyone else here? Anyone else here on this matter? Judging by
these are the normal people that appear, Your Honor.
All right. Well, we got someone coming in late here on a telephone. So I just admitted a phone number ending in 6931. Are you here for Sunset 314 versus Michael Cattell et al.?
No, I'm not, Your Honor.
Okay, well, just sit tight until I call your case, okay? So since it's now 9:02, this matter was set for 9. Doesn't appear that any defendant or defendant's attorney for Safeguard Capital, the party seeking to be in default of the moment, here. So I'm going to find that they're not appearing timely. So Mr. Grammerlich, this you're the moving party, and I set this hearing because, well, I just thought we should probably have a hearing in light of what y'all were asking for, approximately $2.1 million in change. So why don't you go ahead and run through why you believe Safeguard Capital is in default, why you think you're entitled to all the relief that you're seeking as well.
Sure, Your Honor. Back on September 30th, 2025, Safeguard's counsel, Constance Sutton, withdrew on the case. January 26th, the court ordered that the entity obtain new counsel. They did not obtain counsel within the 30 days. On April 17th, 2026, the court again ordered that Safeguard obtain counsel, failed to do it. We then were allowed to file the application for entry of default. We filed for the entry of default, no response within the 10 days. We've since filed our motion for entry of judgment, no response to that motion. It's a liquidated damage case. Sunset contracted to buy a piece of property for $4.2 million. They then got cold feet, decided they did not want to close on the property, fraudulently claimed that the signer was not authorized to sign on behalf of the company, even though we had evidence that this signer had been working with the company on numerous other deals. We have had the property appraised at the time of close. The appraisal came in at $2.6 million. The benefit of the bargain differences is the difference between the contract price of 4.2 and the appraised price at that time of 2.6. That's the $1.6 million in damages. It's a liquidated calculated sum. We also have attorney's fees because they did appear of $58,272. I think we had $700 in costs, and we would also request for post-judgment interest at the statutory rate.
And I do see, I was following along with my notes that while Safeguard filed their answer, as you pointed out, Safeguard counsels withdrew, and Judge Kushner ordered, obviously, to get new counsel. That didn't happen. And then by Judge Kushner's, looks like mid-entry that's filed, a mid-entry ruling filed on May 14th, Safeguard Capital's answer was officially struck and permitted you to file that application that you mentioned.
Correct.
So, all right. And I'm assuming this is a Rule 54B since there's still other claims out there, correct?
I believe so, yes. There are some other remaining claims.
Okay. So if I were to grant the relief, and you would not mind if I have the magic Rule 54B language, so that way the Court of Appeals doesn't get angry at me.
I'd appreciate that.
Okay.
Use the exact language. They're very picky about the language these days.
You know, rightfully so. But I do like to tease my colleagues on the Court of Appeals. So, anything else, Mr. Gramlich, before I open up to any of the other counsel appearing to see if they have anything they wish to argue?
That's all I have, Your Honor.
Thank you, sir. Anything else from anyone else appearing?
No, Your Honor.
Okay, thank you,
No,
Mr.
Your
Gramlich.
Honor.
Right. And I'm sorry, who again, I thought I heard a second no. Did I hear that correctly?
Correct. And Larry Fink, no, Your Honor.
Okay. All right. All right. Well, I do find counsel's recitation of the procedure history to be accurate, with my quick little caveat about Judge Kushner striking the previously filed answer. I do find everything is inappropriate, although, I mean, as I just kind of looked at it when I first got this thing first hit my desk, you know, the sum total of $2.1 million in change, that's a little bit more than what I usually see. Is a little eye-watering, but it does make sense in light of everything in this matter. So therefore, I'm going to grant the motion for default judgment against Safeguard Capital Corporation only. I will add the 54B language, as I joked earlier, to make that modification. I do see when I prepped and peeked, looks like there's been some other things that have been happening